been changed due to Jeff Sessions filing a lawsuit against California for sanctuary cities. So today Professor Blackman is going to be speaking on that, and Professor Kelso will still be giving remarks at the end after his presentation, and then there'll be a time for Q&A also. So thank you, Josh, for being here.
Thank you. Good morning, good afternoon. My first time at McGeorge. Pleasure. Professor Kelso's here. His brother, also Professor Kelso, teaches on my faculty, so I feel like I already know him. I came to you today to talk about the travel ban, but that was not meant to be. Yesterday afternoon around 5 o'clock, you may have heard that the United States government has filed a federal lawsuit against your home state, the Golden State of California. And this concerns what are broadly termed sanctuary policies. I was actually at Attorney General Sessions' speech this morning where he announced the policy, so I can report fresh from the source what's going on. My goal here today is to walk you through the three provisions of California law that have been challenged, give you my tentative take on the federal government's lawsuit. Again, this is tentative. I've had maybe 12 hours to think about this. And perhaps give you a preview of what will happen to this case as it goes to Supreme Court. So, first off, the phrase sanctuary city or sanctuary state doesn't really mean anything. It's a very nebulous term that refers to a wide range of policies that various jurisdictions have enacted. So the term doesn't mean much. But here we have three specific laws that I want to talk about. Okay? The first statute, AB 450, is called the Immigrant Workers Protection Act. This bill puts limitations on whether businesses, as employers, can voluntarily comply with federal immigration officials. So here's how it works, right? You have a place of business, a factory, a restaurant, a farm, whatever it happens to be. ICE shows up. Under the law as it stands now, if a business voluntarily cooperates with the immigration officials without a warrant, right? They show up, so we want to inspect, there's no warrant, they violated state law. That is, it's a violation of state law to voluntarily comply with immigration officials. Before this law, they could comply on their own or not. But now the law requires they demand a warrant. So that's the first bill we have to talk about, AB 450. The second bill, AB 103, creates a new inspection scheme. Now, we all know that the federal government has facilities in states. So let's say the federal government, the Ninth Circuit maybe, has a cafeteria, right, in the building. If California wants to inspect the cafeteria to make sure that they don't have, dirty food, right, clean floors, they can do that, right? States can have health and safety measures with inspections of federal facilities. That's not a problem. But this law does something new. If a facility in California that's connected to the federal government involves immigration offenses, right? If you have immigrants being held there as detainees, there's an additional round of inspections. Specifically, the Attorney General is authorized to investigate whether, quote, due process is being provided to the aliens being held in captivity. No other federal facility is subject to this sort of treatment. Right? If the FBI has a holding cell and they're non-immigrant offenses, there's no inspections. But the mere fact that immigrants are being held here triggers this additional scrutiny by Attorney General. Okay? The third one, SB 54, is called the California Values Act. This is the most, I think, complicated of the three, so let me focus on it a little bit more. Okay? Before this law in California, let's say a state, or let's say a county prison held in its custody a person, right, who broke the law. And let's say his jail sentence was a month, okay? The feds send over a notice, what's called a detainer, saying, hey, we want to pick up this guy, he's not in the country lawfully, and we want to remove him. Before this law, a county in California could say, oh yeah, sure, we're going to release him on March 7th at 5 p.m., just come on by an hour earlier, wait around, and we will release this guy to your custody, okay? No longer. What this new law does is it actually precludes state officials from providing this information about release dates with respect to criminal aliens who might be subject to removal, right? Now the law works is the state officials can only turn over the alien if there's a warrant signed by a judge, or if there's a certain category of very serious, dangerous offenses, murder, rape, you can go down the list. I don't have it in front of me, okay? These are the three provisions. Again, the first one concerns whether private businesses can voluntarily cooperate with immigration officials. The second one is this new inspection scheme from the Attorney General to determine if there's any due process violations in detention facilities. And the third one concerns whether local prison officials can share information with the federal government when they want to pick someone up. Okay, so you got the background. Yesterday, Attorney General Sessions filed a lawsuit challenging these three provisions of law. And there's a certain history here, right? You may have heard that there's a mayor in Oakland who has effectively notified any aliens in her jurisdiction that the feds are coming. And I heard this morning, I can't verify it, that apparently she's thwarted the arrest of over 800 aliens within the city of Oakland, right? Now, before I get to the specifics of this law, I want to talk about an old case that you probably studied in con law. A case called Prigg versus Pennsylvania. Okay? Someone? Yeah. Yeah, thank you. Prigg versus Pennsylvania. This was a decision by Justice Joseph Story from the 1840, 1844, I might be off on the year. Under the original Constitution, there was a clause called the Fugitive Slave Clause. And what this clause said is that there's a runaway slave, there's a power for return of that slave. So Congress enacted fairly early on what's called the Fugitive Slave Act. And this law provided that there was a runaway slave, say from Maryland to Pennsylvania, that Congress could require the return of that slave. Okay, this was a very significant law. People always talk about Dred Scott, which actually celebrated its 150th anniversary earlier this week. Prigg v. Pennsylvania had a much bigger impact on slavery than Dred Scott ever did. Dred Scott was a fairly mundane issue of federal jurisdiction. Prigg, the Slave Act. You ever see the movie 12 Years a Slave? That was a huge problem for decades. Okay, so what did the court hold in Prigg? Pennsylvania tried to do what California did, right? Pennsylvania tried passing a law saying, no, if a slave comes here, we will not return, right? We will not facilitate the return of that slave. The Supreme Court said, no, you can't do that. That federal law is supreme, and that a state law that conflicts with the federal policy is unconstitutional. The question, though, in Prigg was, did Congress have the power to enact the Fugitive Slave Act? And Justice Story said for the court, yes, it did. Right? So if Congress has the power to enact a law that infringes on state autonomy, it can do so, unless there's some independent principle of why it cannot be done. And this is the setup for the case today, right? Does Congress have the power to enact these various federal immigration laws? For the most part, yes, maybe with some slight exceptions. Are these policies people like? Probably not. I'm fairly libertarian. I don't like these immigration policies, but Congress has the power for naturalization. Is there an independent principle on which these policies can be invalidated, namely federalism, right? That is the basis. So today, I want to read you a quote from Sessions' speech today. He said, quote, "Immigration is the province of the federal government. This administration and the Justice Department are determined to make it work effectively for the people. I understand that we have a wide variety of political opinions out there in immigration, but the law is in the books and its purpose is clear." Now, pay attention to this. There is no nullification. There is no secession. Federal law is the supreme law of the land. I would invite any doubters to Gettysburg and to the graves of John C. Calhoun and Abraham Lincoln. Professor Kelso is chuckling, right? What is Sessions getting at here? He is comparing your government to the nullificationists. John C. Calhoun, that is the Southerners who sought to nullify federal law to the extent that it infringed on slavery. I'll give you a more charitable comparison. You're Pennsylvania, right? You're Pennsylvania. You are trying to resist federal immigration law the same way that Pennsylvania tried to resist the Fugitive Slave Act. And you may be good with that. Yes, we want to resist this immoral system of laws. Fine. I'm not going to argue for the morality, right? I actually probably agree with you in the morality. I don't think immigration is nearly where slavery is, but people make the comparison, so I'll let them. But the question is, can you resist? Right? I saw people waving banners outside the hotel today. They resist, resist, resist. Can you resist? Or being precise, can you interfere? And that, my friends, is the key word. Interference. We have a doctrine of law called preemption. Okay? State law and federal law often overlap, and that's not necessarily problematic. But states cannot interfere with the enforcement of federal law. That's where the line is drawn. And there was a case, which Professor Kelso printed out, from a few years ago, 5 years ago, 6 years ago, called Arizona versus United States. Okay? This is a fascinating case. Arizona said, look, the Obama administration is not aggressive enough in enforcing immigration laws. We want to help out. Right? We're going to help out. There were various provisions of the law. Most famous was the show me your papers provision, right? That if you get pulled over at a traffic stop in Arizona and a cop says, show me your immigration papers. The cop says, well, you don't have your immigration papers. I'm going to hold you here and call ICE to pick you up, right? What the Supreme Court said in that case is, even though Arizona thinks that they're helping with immigration, the federal government said, no, you are not helping, you are screwing things up, right? You're interfering, you're obstructing with our program. And the court invalidated not all of the Arizona law, but various parts of it. I can't get into specifics now at another time, but they invalidated large portions of it. The irony is, the lawsuit brought by the Attorney General is a mirror of the Arizona case, right? Arizona said, you're not enforcing immigration law strictly enough, let us help. California says, you're enforcing too strictly, let us resist. Right? So they're mirror images of each other. So let me now walk through each of the three laws I mentioned earlier. The first one concerned voluntary compliance. And if you are a private business, you own a restaurant or a factory or a farm, whatever, and if you want to voluntarily comply with the feds, you are now violating state law. Okay? I think this is a preemption issue. This law is directly interfering with the function of federal immigration law. That is, you have private individuals who want to comply with federal immigration policies, and it's now a crime. My friends, this is Craig, right? Here you had a state, Pennsylvania, that sought to prevent returning of slaves, right? Again, it's an awful precedent to rely on, but the principle still holds. You can't interfere with federal immigration enforcement. The second one's a little bit different. This is the one where there's certain additional inspection of federal facilities for immigrants who are being held. There's something called the Intergovernmental Immunity Doctrine. You probably have never heard of it. But what it basically says is states can regulate the federal government as a general matter, right? If they have health, food inspections at the Ninth Circuit's cafeteria, that's fine, right? If the fire marshal wants to inspect the Ninth Circuit in San Francisco, that's fine. But what they can't do is target the federal government for a specific purpose, right? They can't just target one aspect. They have to be laws of general applicability is the phrase that's often used, okay? Here, the law itself is triggered only because immigrants are being detained. If any other people were in custody, the law wouldn't apply. And it's an additional requirement, right? An additional requirement that these facilities are detained and they're inspected for due process. I think this violates the Intergovernmental Immunity Doctrine. Now, let me make one other point. Even if on the face of the statute, there's no preemption, right? Because the face of the statute says we do this in accordance with federal law. That's nice. There's also something called the as-applied doctrine, right? As applied, as the AG has been inspecting these places, right? That is where you find also more preemption. So I think even if they lose on facial preemption, you get an as-applied violation, which gets the government most what they want. A lot of people think, oh, you know, California law is complying with federal law. That's very nice on its face, but the as-applied is where they get them. Now the third one, I think this is where I might actually agree with Professor Kelso, it's like sometimes with his brother, is where I think Sessions has the hardest part. The third one says, the third provision says that states can't California cannot direct the state to refuse to cooperate with basic immigration laws. This requires a study of a statute called 8 U.S.C. Section 1373, which let me read it to you. It says, a state may not prohibit or in any way restrict any government entity or official from sending to or receiving from the INS, Immigration Services, information regarding the citizenship or immigration status, lawful or unlawful, of any individual. Okay? What this statute says is that states can't prevent their local law enforcement from sharing information about immigration status. Is this statute constitutional? That is the key question, right? If the statute is not constitutional, then California can put such a restriction. If the statute is constitutional, California cannot put such a restriction. Excuse me. So I think the way you have to look at the statute is this. Give me 1 second. Okay. I think the way you have to look at the statute is this. Is the statute imposing a duty upon the states? Right? If it is, there might be a violation of what's known as the commandeering doctrine. This was a doctrine announced in a case, made clear in a case called Prince v. United States in the 1990s. Right, here's what happened. The federal government said, we want local sheriffs to perform background checks before someone buys a gun. Justice Scalia, the opinion, said, no, you can't do that, right? You can't commandeer state officials to implement federal programs. But people don't understand why it was unconstitutional. People say, oh, it violated the 10th Amendment. No, that's not right. You can't violate the 10th Amendment because it merely states a principle. What Scalia said is that this law may be a necessary way to effectuate gun policy, but it's not a proper incident of power. You study in common law the necessary and proper power. They're two different concepts, right? Something can be necessary that is useful to the government, but not a proper, right? Now, why was it not proper? Because it intruded onto local law enforcement matters. The court made this even more clear in NFME versus Sebelius, the Obamacare decision, right? Where a mandate to buy insurance may be a necessary way to regulate healthcare markets, but it is not a proper exercise of federal power. And there were 5 votes for that position. I humbly submit that under Prince and the Obamacare decision, that this section 1373 is not constitutional on its face. And to the extent to which they're seeking preemption based on the statute, if the statute is unconstitutional, California is in the clear. Now, you can say, yay, Josh, go federalism, right? The flip side of this is that Texas, my home state, adopted a statute that punishes sanctuary cities. Guys, we are their mirror image, right? In Texas, if a local city enacts a sanctuary policy, it's a crime. It's the exact opposite. But I think because there's no preemption, Texas can do that also. That is, I think Texas can prohibit sanctuary cities, and California can allow them. God bless federalism. I think it works well. Okay? But that doesn't get you out of the woods either. There is a Fourth Amendment issue here as well. Right? Let's say a person's sentence concludes in jail at March 7th at 5 p.m. And let's say the feds say, you know what, we can't get there until 5 p.m. We bring it by next morning, 9 a.m., right? Can the state sheriff hold someone overnight beyond his sentence to comply with a federal detainer? I think the answer is no, right? Because there's due process. You can't hold someone beyond their period of captivity. So there might be some Fourth Amendment issues here. But at bottom, right, at minimum, this law that California passed was very blatant, right? The people who sponsored it were saying, we are trying to obstruct and interfere with federal law. We're trying to make it harder to deport people. God bless your hearts, right? It's a wonderful goal, but I think you have preemption problems, California. So I think if I had to predict, by the way, it won't even matter what happens in Ninth Circuit. I don't even care. Let's go to the Supreme Court. You know, we'll just skip. I just hope the Ninth Circuit moves quickly and just gets it over with. So the Band-Aid just peeled off and get it over with, right? It won't matter. Judge Reinhardt will find a way to be the new Anthony Scalia with Federalist. It won't matter, right? It just won't matter. It won't matter at all. But the Supreme Court, I think ultimately, the Trump administration will probably lose on the prison release, but will probably win on the other two, if I had to guess. But what do I know? I learned about this yesterday at 5 p.m. This is entirely impromptu. I had nothing prepared, so you're welcome. I'll turn it over to Professor Kelso. Maybe we'll have some Q&A, and then I want to hear from you later. Thank you so much.
Well, this is the sort of thing that law professors just love.
Yep.
Just in time, sort of, it happened yesterday, let's talk about it immediately. Let's bring it into relevance of our classes. My remedy students who are here know that I just love talking about things that happen to be immediately relevant. So, I, in my a couple of hours this morning, decided I would put together a couple of slides.
Whoa.
I know, yeah. So I'm ready to go with a PowerPoint.
I bow in the presence of greatness.
All right, we largely agree on the legal context here. I think a difference is that I think some of the things that are in the complaint, and certainly in a general session speech, are political, but not legal. And in general, there's a big difference. And when you get into court, they're going to ignore all the political stuff. And they're going to focus on, all right, what's the legal standard? Exactly what did California enact? Where's the conflict? And so I think once you do that, you discover there's not actually much here that meets the eye. Now, we'll see. I'm starting out with Justice Kennedy's decision in Arizona versus the United States. Federalism is the issue. And it's been the issue between California and the United States for the entirety of the Trump presidency. It's a federalism question, and I agree completely. We're turning things on their head compared to where they were previously. One of the interesting things about federalism, and you can see it in the quote that I've taken from the case, there are elements of sovereignty the other is bound to respect. And Kennedy recognizes that, and you can see this in the commandeering cases, the 9th, 10th Amendment, if even, technically they don't apply, it's reciprocal. Now, in the context where there's conflict, the Supremacy Clause clearly resolves the issue in favor of the federal government. So I'm going to quote, there's the Constitution, Article 6, Clause 2. What I want to emphasize here is it's the Constitution, and the constitutional issue is not relevant here, it's the laws right there. Oops, I'm back up. It's the laws that are the supreme law of the land. The focus is on law. It's not on the enforcement preferences or methodologies of the executive branch. It's whether there's a conflict in law. And I think you're going to see, at least I think there's a pretty good argument here that we don't have conflicts in law. We have conflicts in the degree to which the current administration wants to enforce the immigration laws. But that's not a preemption problem, because that enforcement decision is not law. The president may want his preferences to be law, and he may actually think his preferences are law. That's not the way it works. We're a country of laws. All right, I've made that point enough now. We have under preemption, there are 3 types of preemption: express preemption provisions. Congress can actually enact a provision that says state law is preempted to this extent. That's not really relevant here. you have something called field preemption. Now, in immigration, there are some areas of immigration law where there is field preemption, where Congress has so regulated so many aspects of that area of law that it entirely displaces states of the power to regulate in that area. So that even if the state enacts something that is, arguably consistent with federal law, it still will be preempted. And that was true of one of the issues in the Arizona case, actually, where one of the things Arizona tried to do was to impose a slightly different registration requirement. And the Supreme Court said, well, it looks like that's, maybe furthering federal policies. But this is an area where there's field preemption, because Congress has so comprehensively regulated alien registration. The state can't do anything. Now, I don't think that's going to be relevant here. I think we're talking about conflict preemption. And there really are two types of that. One is whether it's impossible to comply both with the federal and the state rules. I don't think we have that. Reading the complaint, I think the only preemption they're arguing is the last one, that the state law is an obstacle to accomplishment and execution of the full purposes and objectives of Congress. Now, what I want to emphasize is they're interfering with Congress's purposes and objectives. So you don't look at what the administration wants to do. You look at the statutes that Congress has enacted, and you ask, are they interfering with the full purposes and objectives of those statutes? And I think that's important, because one of the things the court recognized in Arizona is that Congress is at times ambivalent about immigration policy and law. They kind of talk out of both sides of their mouth, or mouths. They enact compromises that aren't necessarily consistent. And to the extent that Congress has this ambivalence about immigration law, that I think makes it a lot tougher to find preemption. Now, that's what I think is a fair presentation of the sort of preemption background. Very quickly, because we want to leave lots of time for questions and comments, I'm doing the same thing that Josh is. I took a look at the statutes, because that's what lawyers do. The first is SB 54, the Values Act. I agree with Josh that they're going to run into some problems about commandeering state officials and resources. And you can see it here. California law enforcement agencies shall not use agency monies or personnel to do a whole series of things that essentially would cooperate and facilitate immigration enforcement. But it's pretty clear what we're doing here. We're saying we don't want our personnel, our governmental personnel, to be doing this. And if the only way that the federal government can then make our public officials and employees assist them is by commandeering them into assisting, I think you got a serious problem. So we'll see on that one. I think I agree there's a very interesting legal question there. And I should say on this first one, it's not perfectly clear to me that the federal law actually purports to commandeer state and local officials. As drafted, it looks a little more to me like it says, nobody can prevent, it doesn't say that even, nothing in this statute shall be construed to prevent cooperation. Well, that's a hell of a lot different than saying the state may not prevent cooperation. So I think there's a little weakness in this part of the complaint. Employer rules. I think this is an outright loser for the federal government. And we disagree on this. And I think it's an outright loser because of the very first clause in the state statute. Except as otherwise required by federal law. Duh! How can there be conflict preemption when we've said If you're required to do by federal law, you have to do it. Now, why is that language there? Well, of course, because, our drafters of our legislation, they're not idiots. They know there's a preemption problem, so they draft in a clause at the very front that says, look, no preemption. Now, it's going to be an interesting question, I think, not so much about conflict preemption, but in this notion that we somehow are discriminating against the federal government. And to tell you the truth, I don't know what the hell that claim is. The federal government, discriminating against the federal government? Well, what clause in the Constitution protects the federal government from discrimination? I don't know. That one I was curious, but I suspect that was added to the complaint because I'll bet DOJ's lawyers recognize they got a problem on preemption. And they need to try to have some other theory. Maybe it's your intergovernmental immunity thing where the discrimination might well be an issue. In any event, the second thing I would note at the end of my first bullet, notice that it says, this section does not apply if the immigration enforcement agent provides a judicial warrant. Okay, if you provide a warrant, you come in. The only thing we're telling our employers not to do is provide voluntary consent. Does that interfere with normal immigration enforcement practices? Yes. But then that goes back to my major point. Interfering with the federal government's normal executive branch practices doesn't violate the Supremacy Clause. Unless Congress has written those practices into a statute, then you've got a preemption argument. We'll see if I'm right about that. I do think that these things were drafted pretty carefully by California's legislative council. Okay, as you can see, the except is otherwise required by federal laws in all of those. The final one is the review and report that gets into the intergovernmental immunities challenge. The thing to remember here is that what we're talking about are facilities that are generally owned and operated by county or local government or by private entities. And they're being used for immigration purposes pursuant to agreements with immigration authorities. And as Josh has said, we generally, even if you have a federal authority or federal building, and certainly, these are state and local buildings or private buildings, we generally still inspect those buildings for code violations, elevators, all sorts of stuff. I agree the real difference here, and this is going to be a close one, I think, the review is for conditions of confinement, standard of care, and due process provided, and the one that seems the most intrusive, the circumstances around detainees' apprehension and transfer to the facility. Well, that seems to be pretty intrusive into the federal government's enforcement. It's like we're going to do an audit of how you're enforcing the immigration laws. That seems to go pretty far. If I were the state, what I would argue is the following. At least the first two of my bullet points up here from the statute are, it's impossible for these to be, those two alone, inconsistent or an obstacle to anything. All they are a report. It directs the Attorney General to write a report. Well, that doesn't interfere with anybody. He can report on whatever the hell he wants to report on. The third bullet here is the one that is, I think, more problematic. It says the Attorney General shall be provided all necessary access for the observations necessary to effectuate reviews. All right, that starts to sound a little more intrusive. Personally, I think with respect to the county detention facilities and local detention facilities that are government-owned, I would come out if I were on the bench and say, well, no, wait a minute. Federal government, you've got an interest in them, but the state does too. State has a legitimate interest in knowing whether its facilities are being used lawfully. And are the detainees, are they being properly treated? Are the conditions of confinement adequate? We know that in a lot of counties, they're not providing medical care very well, or mental health care. So the state does have a legitimate interest there. The private block detention facilities gets a little more problematic, even further. But again, doesn't the state have a legitimate interest in knowing that private prisons in California are respecting the rights of the people who they're detaining, even if they're doing it pursuant to a lease with the federal government? Again, I think that one's the most intrusive of federal interests. But overall, as you know, I think the state is going to be in a pretty good position here to litigate this. I agree with Josh. I think we don't know who the case has been assigned to in the Eastern District. But he says it doesn't matter. And you know, the Ninth Circuit, unless you happen to get a particular...
It's mathematically impossible. I've done the math.
Okay, mathematically impossible. I do think on the question of whether it gets to the Supreme Court, you know, the Supreme Court most recently, the administration tried to get quick review of one of these cases, and the Supreme Court said, no, you got to go through the Ninth Circuit first. So I think they will go through the Ninth Circuit, and then we'll see what happens.
Okay.
Very good. We'll take questions now,
we
I
have
think.
room until 1 o'clock, so we have 20 minutes.
Yeah, I think Professor Kelso made a very good point. Perhaps one difference between this and the DACA case is that here, California's laws change the status quo. That is, for decades, California has permitted the federal government to act, and this is a new thing. And they're basically trying to stop this new thing, whereas with the DACA case, they were trying to change the status with people in a DACA. I'll respond to a few points very briefly. Oh, wait, I have your slides here. I can steal your thing. Very good. Okay, which one?
Yeah, I get it.
I got it. Okay, so this one, right? Yeah, they're not idiots. They're except as otherwise required by federal law. That doesn't get you out from federal preemption. Merely saying it doesn't make it so, because very often you can have preemption. Oh, but we're not. So there's another constant mention, as applied. And if as applied they are interfering, then it's just as good as preemption. The second one, this intergovernmental immunity doctrine, I agree. It's not written in the Constitution. There's no immunity clause. I think it comes from the supremacy clause. Actually, it comes from McCulloch v. Maryland. I already talked about Prigg, let's talk about McCulloch, right? What were the facts of McCulloch v. Maryland? Remember this? Maryland put a tax on the Bank of the United States, right? They said, your Marshall said, well, to determine if this tax is constitutional, we decide, can Congress charter the bank? Congress could charter the bank, therefore the Maryland tax went out. I think this is McCulloch v. Maryland and Prigg. I think that's actually, you know, want to go old school, the Marshall and Story, 1-2. The third point they want to respond to concerning the warrant. The statutes do permit interrogations that warrant. In fact, if you're within 100 miles of the border, Congress said you don't need a warrant for a search. So if you're in San Diego, which I think is within 100 miles of the border, you don't need a warrant, period. The imposition of a warrant requirement expressly conflicts with that statute. So I think there is a lot of express preemption there. Okay, I'll shut up now. The acoustics in this room are awful. Okay, it's very hard to project. This mic does not reach me. There it is. Okay, so please, I welcome your questions to me and Professor Kelso, and we'll stay as long as you got them. Okay, yes, number one.
So on the matter of conflict preemption, the regs and also in regards to AB 450, the federal regs that implement the I-9 inspection review process are pretty extensive and pretty thorough. They provide, as required by federal law, that a employer must make available their I-9s after the issuance of an administrative warrant, not a judicial warrant.
Yeah, the statute does as well. Same thing.
So, I mean, to me, that seems like the most clear conflict between the two in regards to AB 450. I'm just kind of interested in hearing.
Professor?
And you know, this is the disadvantage of not having much time to do this. My recollection is this was 450. My recollection is the statute actually has language directly addressing production of the I-9s.
I think it says that they can do a verify, but they can't re-verify. I think that's the provision.
That may be it.
Yeah, I think he has the papers. I don't have any papers in front of me, but I think what the California law says is that when the person's initially hired, they can verify their authorization, but they can't re-verify them. The problem with this is that under federal law, you have an ongoing duty to determine if your employees are here lawfully. Because you might be here lawfully, you might lose your presence, your visa expires, whatever, right? So the California law prohibits employers from doing that which the law requires from them. And by the way, that's not a defense for a federal prosecution, right? If an employer in California employs someone not here legally, says, well, the law doesn't let me check their status, they're still subject to federal prosecution. So I think
additional language, though. The statute provides this subdivision shall not apply to I-9 employment eligibility verification forms and other documents for which a notice of inspection has been provided to the employer. Now, I don't know enough about all the the immigration regs to know whether, does that clarify or get rid of the conflict? But it's clear to me they were aware in the California legislature that the I-9 forms are given different treatment. As a practical matter, would it interfere? Probably would. They've also got some provisions in here dealing with giving 3-day notice to the employees.
Yeah.
Well, wait a minute, how does that work?
That's, yeah.
But then again, I do think that in part this case will come back to the difference between are you an obstacle to what Congress's purposes are, given that Congress is in the immigration area isn't exactly clear all the time, versus we clearly are contrary to what the current administration's policies are. But I don't know that that's a preemption issue.
I guess actually just a quick follow-up to that. Would we read into the federal regulations when trying to determine whether it's in conflict with the Congress?
This gets really murky, and I don't mean to dodge your question. Preemption is a bit of a mess. It really is. The Arizona case had a very fuzzy line of what obstruction, what interference was. It's not good. So I don't have a clear answer for you. I do agree the California draftsmen were not idiots, and they tried to draft this in a very precise way to tiptoe around these various doctrines. It won't matter, we'll see what the justices say. Yeah. Other questions?
He didn't dodge, that's the right answer on the regs.
I'm trying not to dodge.
That's a tough one.
I was terrible at dodge, I was always pick last as a kid, so you got the wrong person. Yes, sir, in the front.
Mr. Kelso, you emphasized that the statute refers to laws and the intent of Congress. Isn't the intent of Congress to put up a formula for the framework for the administration to execute? And therefore, whatever Trump wants is, as long as it's consistent, is the intent of Congress.
Normally, I would agree with that, but I think when you read Arizona versus United States, with respect to, and I forget which one, with respect to one of the types of provisions, boy, the court made it clear that there really wasn't a clarity of purpose from Congress. As I recall, it dealt with the one where there was a compromise that Congress had adopted. The arrest of removable aliens, where the state wanted to say, we can arrest you, we create a state crime that you're an alien who is undocumented and removable. And it wasn't inconsistent with anything in the statute. But the Supreme Court said, Congress tiptoed all around that issue. And because of Congress's clear sort of ambivalence, we're going to say that that's preempted. So I read that in Arizona and came away with the impression that the court doesn't believe they're getting necessarily crystal clear signals from Congress in the immigration laws. Now that just may be my reading of.
Let me provide another wrinkle. So attached, it wasn't just a complaint filed, they also saw a preliminary injunction. And they attached a declaration from a State Department official. And the State Department official said something I hadn't considered. Deportation is a matter of foreign policy, right? When the United States has a deportation policy, they often coordinate with foreign countries saying, will you accept this person we're deporting? What the complaint said is, this California policy is mucking up our foreign policy, that we are not speaking with a single voice, that now we have different immigration policy in different states. This, I think, is a very compelling argument, even for maybe Breyer or Kennedy, right? That if you have a single policy in immigration, and it's varied by states, you frustrate. Because imagine, right, we have an alien from XYZ country, right? The State Department says, hey, we want to return this guy to your country. Can we return him? That requires some facilitation. That's not an automatic. But now California says, no, we will not allow our people to be rounded. We'll give them advance notice like in Oakland, right? It screws things up. There was a case about 3 or 4 years ago, Zivotofsky versus Kerry, right? In this case said, can Congress require the president to stamp a passport of someone born in Jerusalem as born in Israel? And the Supreme Court said, no, you can't do that. It's an exclusive power for the president of recognition. Guess what? There's a lot of foreign policy issues in here where I think Congress and the president think this is a federal matter. So you asked me how they're going to resolve it. I think the tiebreaker might actually be the foreign policy. Read that declaration. It's about 5 pages long. But it makes this point, I think, very cogently. This hasn't been picked up yet. But that's in there. This is not California's business, how we manage our foreign affairs. Unless you secede, in which case, God bless you. You go with the 5th largest economy in the world, whatever the number is, right? Good luck. Gas will be even more expensive. It's like $1 more.
In the north here, we want to secede from the south part of California.
So we've got our own 3 states.
We've got our own internal.
A 3-state solution, maybe. Yeah. Texas will secede. California will secede. We'll go back to the olden days, right? So other questions. God bless Texas. Other questions? Come on. Something else. Yes, sir.
My question is about citing a case in California.
Which case?
My question is that the Attorney General of the United States is supposed to cite a case, which is United States with Arizona. So my question is, as a counter argument, do we have any cases to cite for California?
Okay. So if you couldn't hear it, it was a little hard to hear. The question was, the Attorney General relies on the Arizona case. Are there any contrary cases? I think the answer is actually yes. A lot of the federalism decisions.
And I would say a contrary case is Arizona versus United
Yeah.
States. I think they've learned the wrong lesson from Arizona.
Yeah. I agree with Professor Kelso. Arizona is a Kennedy opinion, and as a good Sacramento person, he often talks at both sides of his mouth. It's funny, Justice Scalia made fun of Sacramento in the Bergefell decision, you know what to say. Justice Scalia said that on the court, there is no true Westerner. He said California doesn't count. Scalia was trying to say that, there's not any geographic diversity, but there are all these justices from New York, and only one justice from the great in-between, John Roberts from Indiana. He said, there's not even a single Westerner. California doesn't count. So there you go. Other questions? Yes?
How long do you think that this issue will take to be decided, the full process?
Okay, so the question was, how long do you think it will take to be decided? This is why it says, I don't care who they draw on the district court. I hope that person moves quickly. It doesn't matter what they rule. It's entirely irrelevant, but let it move quickly. The government filed what's called a preliminary injunction, which usually means move fast. Mr. Kelso, 3 months, 4 months, is that reasonable?
Well, yeah, I mean, they'll have to get assigned to a judge. A judge typically will call for a hearing within 21 days or so. The parties have to brief. I'm sure various parties will seek extensions of time to brief because it's such a complex case. So, it'll probably get to the judge, I would think, within 2 or 3 months. Now, a judge, you're going to have to, for this, you have to have a written opinion. It's a complex issue. I don't think it's, as you can tell from our presentation, it's not an open or shut issue. And there are a series of difficult things to work on. We may not see a district court opinion here until, I don't know, 4 months at the earliest. And you may do something where he says, I deny it, but I'll give you my opinion a little bit later.
Yeah. I mean, at this point, the government wants to get to the Court of Appeals as quickly as possible. I mean, usually the routine is you seek a district court injunction, then you go to the Court of Appeals, and you seek en banc in the Ninth Circuit. I think they skip en banc. It's probably a waste of time.
Yeah. And
get this to a court they'll actually care about, which is the Supreme Court, which, that's only
in terms of, for my remedies students, an interesting fact here is they did not seek a temporary restraining order.
They did not.
If they wanted to get a quick decision, they would have asked for a TRO. And apparently there's not enough irreparable injury to get a TRO here.
Also, they waited too long.
They waited too long. That's right. If you sit on something, and here even the complaint talks about, for example, reviews that have been conducted months ago, and then strategically, if you file for a TRO, you're going to get a quick decision. Of course, it's likely in the Eastern District the decision is going to be no. Do I really want to have, I file and 2 days later the court rejects it? I don't want to lose that early. So if I'm going to lose, let's give ourselves some time here, 3 or 4 months before we lose.
There's also a good venue issue. Could they have filed this in the District of Columbia? I think the answer is no. I don't think California has any contacts there. So I think they were stuck to Sacramento. No offense, Sacramento.
Well, they could have filed in San Francisco.
Oh yeah, that'd be a lot better, right? I mean, come on. They could have filed in Mexico with the same judgment. The southern district of California. Other questions? Yes.
I wanted to go back for a second to your comment about the foreign policy issue.
Yeah.
And correct me if I'm wrong, because I don't understand how this works. Wouldn't all the deportations be facilitated by the federal government, not by the individual states, correct?
Yes.
Okay. So if that's the case, then wouldn't all that other stuff between individual states and their individual policies basically come out the wash before the individual alien was in the hands of the federal government and thereby dealt with the foreign country?
Yeah, so the question is, if it's ultimately the feds removing a person, what difference does it make that the states would do, right? And I think the answer is in terms of numbers. If the US government anticipates deporting, say, 5,000 persons to a country X, and let's say 1,000 are in California, that messes with their negotiation strategies in advance, right? The US sets its priorities. We want to deport X number of people. If California obstructs that and makes it harder, it interferes with our diplomatic communications. And I'll just read a quote from from the affidavit. It says, it makes it harder to keep control of the message we're saying to foreign states, right, if individual states are frustrating it. Because if, let's say, California enacts a statute, and then so does Washington, and then Oregon, right, and then New Mexico, and you go down the map, right, this becomes a very quick way of interfering with how we can communicate to foreign governments that this is an important issue. So I agree, at the margin, it might not make much of a difference, but I think this will play into the decision, especially if the court upholds California's laws, my God, every other state in the West Coast is going to copy it very quickly.
Certainly the liberals on the Supreme Court, perhaps one response they would have is, it doesn't seem that the administration is concerned about consistency of communication to foreign governments. That doesn't really seem to be something they care about. But that's a snarky response, not really a legal response.
Yeah.
Yes.
Yes, sir.
This is for Professor Kelso. I have a question about, you said that the court or the states are not concerned or shouldn't be concerned about the executive, how the executive approaches or what they want. And so the question comes from the fact that, so the Supremacy Clause, the laws of the United States are supreme. If the executive is responsible to faithfully execute the laws, then, and Congress passes immigration, there's an INS, there's an ICE, they promulgate rules, Congress doesn't overrule those rules, the executive is responsible to enforce those. How is it that the states then don't have to listen to the executive?
Well, and for preemption purposes.
Correct.
Yeah, the answer that I have given, and it is not one supported by any clear Supreme Court precedent because there isn't much in this area. But going back to Scalia's and now Gorsuch's favorite approach, I get that from reading the words of the Supremacy Clause. It talks about the Constitution and laws of the United States. That's the basis for preemption. And you will never be able to convince me that a single Attorney General's decision of how I want to set priorities is a law. That's not a law. That's how they want to set priorities. The issue came up in the Obama administration, this precise sort of problem. DACA is perhaps an example of this. Was DACA actually a law? No. So, okay, what is it then? Well, it was a decision arguably it was a decision about how they were going to place their priorities. People who are opposed to DACA say, well, no, he promulgated it in such a way that it was a rule of general applicability and it applied to everybody. So it looked a lot like a law. But I mean, that's why I think that's an interesting issue here. Does the Supremacy Clause, how much does it incorporate of federal practice and enforcement? And I don't know the answer to it. I do think, reading Kennedy's opinion, there's so much language in there about, are you preempting what Congress has enacted? Not so much what a particular administration is trying to do. And I could be 100% wrong about that, I don't know. But for the textualists of the world, I think you read the Supremacy Clause carefully. One of the things that I saw in the complaint, where they actually are sort of, okay, what are we actually bringing here? What they said was, these provisions, individually and collectively, have the purpose and effect of interfering with the enforcement of federal provisions. Yeah, that may be true. That's not what the Supremacy Clause says. Enforcement is not law. It's just enforcement.
Yes, sir, in the back.
I'm just trying to understand how that provides a basis for ongoing governmental function. It sounds like you're arguing that administration to administration, you kind of get to say whether you like it or not, or we get to nitpick and say, well, we don't like this administration, so let's create this notion that this is just enforcement. No, there's no supremacy issue here.
So I raised a hypothetical. So when the Arizona case was being argued, we had a presidential election, right? And let's say in the middle, Mitt Romney was elected, and he changed position. You know what? I love Arizona, right? I like what Arizona's doing. They're helping us make America great again, right? Would the case suddenly turn out differently? So I think the enforcement priorities did play a role in the case. Eric Holder brought this suit, but Mitt Romney said to withdraw it. Does that change the Supremacy Clause? So the views of the incumbent administration shouldn't play a role, but they did play a role in Arizona.
Well, and my quick, facile, get off the stage answer to your question is, I don't have to deal with a broader question of what constitutes law across administrations. I know that just for purposes of the Supremacy Clause, for those narrow purposes, because that's what the clause says. It doesn't say federal enforcement decisions are the supreme law of the land. But that's a too facile answer to get off your question. Fortunately, we're running out of time.
And this Constitution is so old, it doesn't have the 27th Amendment in it. Any other questions? Thank you all so much. I appreciate it. Thank you so much. That was fun. You did your homework. I'm glad you just started. I haven't been in a minute. I just did it last night.
Fascinating set of issues. Did you fly in last night?
I spoke at Santa Clara on Monday.